5 seconds to go. Start. Learned Counsel referred to the judgment in Mano Karan versus State of Tamil Nadu, wherein this court refused to entertain the case within exception 4 of section 300 of the IPC due to the nature of injuries, which showed cruelty and brutality meted out to injure a person on the root of the neck. In applying the said principles to the facts of the present case, it is submitted that there were 11 injuries on the vital areas such as skull, chest, and abdomen, leading to breaking of sternum as well as second, third, and fourth rib to demonstrate that the appellant acted with brutality. Hence, the present case cannot fall under the fourth exception to section 300 of IPC. Learned Counsel for the respondent also made a reference to section 86 of the IPC, which reads as under: in cases where an act is done is not an offence unless done with a particular knowledge or intent, a person who does the act in a state of intoxication shall be liable to be dealt with as if he had the same knowledge as he would have had if he had not been intoxicated, unless the thing which intoxicated him was administered to him without his knowledge or against his will. It was thus the submission made by the respondent that merely because the appellant and the deceased had consumed liquor together, full knowledge is liable to be attributed to the appellant, and the defense of being under the influence of liquor is not something which was available to him. It was further contended that the benefit of section 300 fourthly extends to act committed by an offender with the knowledge that the result of such acts will be death approximates a practical certainty, a very high degree of probability. The nature of injuries in the present case indicates that death was a practical certainty. Therefore, the conviction of the appellant was liable to be sustained under section 302 of the IPC. We have examined within the limited contours of the aforesaid facts and the principles of law enunciated. There is no doubt that the parties were closely related, being the father and the son. There was no prior dispute. Liquor got the better of the appellant. That, however, is no defense in view of section 86 of the IPC. We have to thus turn to the fact that there was no prior intent, but in the sudden fight, injuries were inflicted. It is necessary to look to the injuries in this behalf, which had been enumerated herein above. There were 11 injuries. It is not only the number of injuries, but where and in what manner they were inflicted, even if it is by a piece of nagar wood and not by a dangerous weapon. There were multiple injuries on the head, on the right side, on the front side, on the back left side, near the left ear, on the front and left side of the neck, and on the left cheek. Stop.